Hello again. This is Canon Law in Exile, video 2, uh, continuing with Penal Law, Lesson 6. Okay, I wanted to make two remarks about late sententiae penalties before going on. And one is that when we talk about declared and undeclared late sententiae penalties, we kind of have this expectation that eventually the penalty is going to be declared. Um, that may or may not be true. A lot of late sententiae penalties never are declared. So just keep that in mind. It sounds like there's just an interval between the commission of the crime and then there's going to be an eventual declaration. There might or might not be. Sometimes there is, sometimes there isn't. Um, so just kind of keep that in mind. And then one other idea, just really a comment. Is there any problem? Is there a problem with having a lot of undeclared late sententiae penalties? I'm going to suggest yes, or at least arguably so. Um, One problem is that there is uncertainty about whether the person has incurred a late sententiae penalty. Now, I used the example in the last video of you physically attacking the Pope, and we just assumed that you actually had done that, and so you incurred the penalty of the late sententiae penalty of excommunication. But let's think more about that. Um, Recall the factors listed in Canon 1323. Now, this would have been really about the first day that we talked about canon law back on March 10th, maybe March 13th. It listed several factors that will prevent a penalty from being occurred, even if the action happened. The attack on the Pope happened, and it was you who did it, but there were factors that might prevent the penalty from being incurred. Some of these factors were ignorance, force, grave fear, things like that. Um, and then in the next canon, 1324, we saw some factors that don't prohibit a penalty from coming into force, but they ameliorate it. They make it a lesser penalty because your action is considered partially not your fault. Well, think about that. What's interesting about this instance of an attack on the Holy Father is that we had this fairly recently. You might remember, I forget when, but in the last couple years of Pope Benedict's papacy, at one of the masses in St. Peter's, I think it was around Christmas time, but I'm not sure. A Swiss woman jumped over the barricade and lunged at the Holy Father and knocked him down. Um, I mean, really knocked him down right in the procession. I think he was either processing into Mass or out of Mass. Um, so, we know from our previous discussion what's the penalty? Late sententiae excommunication. Um, but this woman, again, I think she was a Swiss woman. Was she actually excommunicated? Actually, almost certainly not. She almost certainly was not excommunicated. It turns out she was a disturbed woman, and as a result, she may have lacked the use of reason. Again, I'm not sure how much examination was done, but a real possibility is that she actually lacked the use of reason and that she didn't have control over herself when she jumped out at the Holy Father. Well, if you look at Canon 1323, the one we've just been talking about, section 6, it talks about that. If you lack the use of reason, then you don't incur the penalty, even if you did the action. Then there's another section that says, in the same canon, that says, if you did the deed but you were ignorant of violating the law, then also the penalty is not incurred. So that's it's very likely, even though we have this recent example of an attack on the Holy Father, that the woman actually never did incur the penalty. We don't really know, though, because I don't think anybody examined it with the lens of penal law. And this kind of uncertainty, I think, is why some people dislike latte sententiae penalties. And we impose these penalties because the crimes are very serious, but then we have these things that take away the fault, and so um, it can be difficult to know whether or not someone has actually incurred the penalty. Last year, there was actually an interesting debate about this. I mentioned this canonist before, Edward Peters, and he takes this interesting position that, as you know, abortion is a crime for which there's a late sententiae excommunication. But Peters takes the position that he does not think any woman actually is excommunicated by the canon, specifically because of all of these factors diminishing the culpability, or what we talked about before, imputability. So he thinks that many women who have abortions are ignorant of violating the law, or they're forced into it, or something like that. So that was his position. And someone at the same seminary where he teaches, Sacred Heart in Detroit, Monica Miller, took the exact opposite position. She's not a canonist, but she did a pretty credible job of arguing the canons in her own right. And she said, no, on the contrary, they this penalty is actually incurred by women who have abortions. So, or not only women who have abortions, but people who perform them as well. So anyway, can't really resolve that debate there, but just very interesting that two people teaching at the same seminary uh, disagreed on this idea. We have this, it just goes to show you the uncertainty that we have with late sententiae penalties. So anyway, that's why these things are controversial in some ways, and why when the old code was being revised in the 1960s, there was a call for having less or fewer late sententiae penalties. I guess we do have fewer, but it still seems like there are quite a few. Okay, let's move on to another subject. This would be at around page 477 of Woodall. This topic is the application of penalties. How does it happen that a penalty is actually applied to you, or how is an event investigated? Um, okay, the first question is there evidence that a crime has been committed and that a particular person is responsible for it? If there is, again, two things: evidence that a crime has been committed, or a delict. Remember, delict is our word for a church crime. Uh, we've got that, and evidence that a particular person is responsible. Then the ordinary initiates what is called a prior investigation. And a prior investigation is provided for in Canon 1717. And it's called prior investigation because it's the first step in the process before a penal process or penal procedure can go forward. So the ordinary opens this prior investigation and tries to answer these two questions. Has a crime been committed, and does it appear that a particular person is responsible? If the answers are yes, then the ordinary decides either on a judicial process or an administrative procedure. These are our two options. We've talked about them before. Judicial process, also known as a trial. You've got a judge there. You've got um, essentially fairly wide-ranging protections for the rights of the accused. And the other option is an administrative procedure. Administrative procedure is not decided by a judge, but it's going to be decided by the ordinary himself. It's going to be a quicker procedure, and it's going to have less protections for the accused. The law favors a judicial process. That's stated in Canon 221 and Canon 1342. In fact, you cannot initiate the administrative procedure. You can't go that way unless you have just reasons to do that. Um, Unfortunately, though, or some people would say unfortunately, I guess I would be one of those, but make up your own mind. Um, there's kind of a disjunction between the law and the practice. As we've just said, the law favors the judicial process. These canons 1342 that we just talked about says this is the preference. This is the default is to have a judicial process or a trial. You need specific reasons if you want to have the administrative procedure. However, even though the law favors a judicial process, in fact, it's become more common to have administrative procedures. Uh, it- Basically, if an ordinary has a choice between the two, he almost always chooses an administrative procedure. Um, why does he do that? He does it because it's quicker and easier. If it were your decision, you would probably choose an administrative procedure too. It's simply easier, and each one, the judicial process and the administrative procedure, each have their own benefits, and we've just kind of described them. The main point in favor of the process, the judicial process, is greater protection of the rights of the accused. The main point in favor of the administrative procedure is it's going to be quicker. So anyway, those are our main points about how penalties are imposed, and this is also an issue that might figure into your reflections on your thought piece. Again, do you feel like do you feel like we need to have more protection of the rights of the accused? If you do, then you might feel like, hey, we should stick closer to Canon 1342 and actually um, require there to be more judicial processes and fewer administrative procedures. But if you feel like more like, no, we need to speed these things up, we need to get all these cases decided more quickly, you might say, no, it's a good thing to have more administrative procedures, and maybe the law shouldn't even favor one over the other, but just have an equal choice for the ordinary. So just think about that, and I think you'll have more to think about when you read some of the articles that I've sent you and that are on our syllabus. One or two final points. If a penalty is imposed, or if you have a penalty, it applies everywhere, but it's suspended to let the offender receive the sacraments in danger of death. That's Canon 1352. Also, if there's a penalty but the offender or the accused decides to appeal, the appeal also suspends a penalty. So let's say it's excommunication, he would be able to receive the sacraments because the penalty is suspended while he's appealing. Okay, that's really the end of our discussion of the application of penalties. Next time, what we're going to talk about is the cessation or the ceasing or the end or the lifting of penalties. That's going to be our next subject. And that's a very important one because for those of you who are going to be ordained, we're going to discuss which penalties you might be able to lift in the confessional as a confessor. Thank you very much.